I'm Mike, your guide for this video. In 2022, the Florida Supreme Court created new rules that expand the use of video conferencing in Florida civil court cases. As a result, lawyers in Florida will likely appear by video conferencing before the courts more frequently than ever. We can imagine a future where some civil cases are resolved exclusively in the digital courtroom without anyone, including lawyers, litigants, witnesses, experts, judges, and court personnel, ever stepping foot into the physical courtroom. For lawyers, this change to how civil cases can be litigated by remote appearance means that lawyers must know the expectations that apply to video conferences in the courts, and they must know how to use video conferencing for effective communication. This video will introduce you to information that will help you better understand video conferencing in civil cases and communicate more effectively in a video conference. This video is not a comprehensive review of all the laws, expectations, or best practices for video conferencing in Florida civil courts. Instead, it provides a sampling of important information about video conferencing. As always, it is up to you to research authorities that govern video conferencing. We will give you a head start on that research with a bibliography of resources. You'll find that bibliography in the notes for this video or made available to you by your facilitator. So let's turn it over to Chris, who is at the Bench and Bar Conference in Miami, interviewing lawyers about video conferencing in circuit court civil cases in Florida. Do you know more than they do? Let's find out. Chris, over to you.
Thanks, Mike. I'm here with Ann. Ann, aren't you a personal injury attorney?
I am, 2 years in the game.
Let me ask you this question. Do you think that a critical witness could testify in a jury trial via video conference?
Critical witness. So like an eyewitness?
Yes, and in a jury trial.
I would probably think that the judge and the jury would want to see that type of important witness in person. So I'm going to go with no, absolutely not.
Ann is wrong. Under Florida's new 2022 Rules of Judicial Administration, a court official may allow a witness to testify in a civil proceeding by video conference when a party asks for the witness to appear or if the court decides to allow it. This includes testimony at jury trials. A party who wants to present testimony by video conferencing must ask in writing and show good cause for this delivery method. Under the new rules, the oath witnesses must take before giving testimony can also be administered via video conference. The person giving the oath no longer has to be physically present with the witness. The rules make an exception for involuntary commitment proceedings. Now let's see what Ann thought of that answer.
Wow, I had no idea. Of course, I thought it would be acceptable for depositions, but for a jury trial, I guess I was wrong.
All right, and so if a witness can testify via video conference at a jury trial, what do you think about this? Can a juror appear via video conference for a jury trial?
Okay, I definitely know this one. It's no way that a juror can sit for a whole jury trial over the internet or on Zoom. So I'm going to say absolutely not.
Once again, Ann is wrong. Under the new rules authorized by the Florida Supreme Court, jurors and potential jurors can appear by video conference for court proceedings. In the case of prospective jurors, the discretion to use video conferencing lies with the judge. Specifically, a circuit court judge may allow prospective jurors to appear by video conferencing to determine whether they will be disqualified, be excused, or have their jury duty postponed. In addition, a judge may allow prospective jurors to participate in voir dire and impaneled jurors to participate in trial through video conferencing if this is allowed by another rule of procedure. The Florida Rules of Civil Procedure now allow voir dire and civil trials to be conducted by video conferencing when the parties stipulate to it and the court authorizes it. Let's see what else Chris has for Ann.
I'm 0 for 2, but this one has to be right. I can depose witnesses on Zoom, right?
What do you think?
Well, I've been doing it for at least a year, so I'm gonna say yes, because if not, then I might be in some trouble.
Ann is right this time. Deposition testimony may also be taken by video conferencing when the parties agree or the court orders it. And that same system applies to Florida mediation and arbitration. Good job, Ann. What these new rules mean in Florida is that lawyers will spend a lot of time doing their work by video conferencing. But do lawyers know how to do a good job at that? I see Chris has cornered another conference attendee.
Thanks, Mike. Hey, Phil, come on over here.
Yes,
Can I ask you a question?
sure.
Do you use video conferencing at your law firm?
Oh, yeah, all the time. Use it for depositions primarily, but the court as well. I've done direct examinations, cross-examinations. We use it regularly.
Do you think that the background that you use on video conference is important?
Oh, very important. It's very important.
Phil is right. When lawyers appear in a physical courtroom or a judge's conference room, they can rest assured that the background is professional and not distracting. The judge is in complete control of the courtroom space, after all. But now that lawyers may appear in court remotely, lawyers have to pay more attention to their backgrounds. It's not just about the aesthetics of your environment, it's about protecting the decorum and dignity of the judicial system, showing respect for the judge and others, maintaining confidentiality, and perhaps surprisingly avoiding bias. A professional background for video conferencing should reflect the seriousness of the situation and reflect respect for the judicial process. Judges have expressed concern that remote proceedings diminish the dignity of court proceedings. When appearing before a judge, you should consider your office or home office an extension of the courtroom. Minimize anything in the background that is distracting, overly informal or personal, or inappropriate for a courtroom. Think too about whether your background introduces bias. Does the background show a surrounding that could, even subconsciously, influence perceptions about you or your client? For example, while you might typically have family pictures behind you on your bookshelves, consider removing those for court video conferences. If you don't, a judge may ask you to do so, particularly where the proceedings involve jurors. Backgrounds for video conferencing might also compromise confidentiality. Lawyers are obligated to keep confidential all information related to the representation of clients. But what if your background reveals a stack of files or a banker's box clearly labeled with client information? Failing to remove that from the video conferencing background might inadvertently compromise your ethical duty of confidentiality. Virtual backgrounds, while often a good choice, can cause their own problems. A virtual background might be distracting or too informal. A beach scene is lovely, but probably not appropriate for a courtroom proceeding. In addition, sometimes virtual backgrounds distort the features of the speaker. A speaker's hair might disappear, hand gestures might disappear or become distorted. Even physical objects that you mean to show might be distorted or disappear. These visual distortions can distract others and even change the meaning of your message. If you choose a virtual background, have someone give you feedback on how well that background works and if it causes distortion. Let's see what else Phil has to say.
One for one. What else do you have for me, Chris?
All right. Well, let me ask you this. When you're using video conferencing, are you most often at your office or at your home?
Mostly at home.
Okay, now when you're at home, can anybody see or hear you?
Well, you see my wife, she works from home as well, and we share a home office. But for those conversations that are not public, you know, there's attorney-client privilege information involved. She steps out for those. But if it's something like a hearing, we're not as concerned. I just ask her to be quiet and stay off camera for those.
What Phil is doing is probably a bad approach. Although it may be that some hearings Phil attends are open to the public, those that purportedly anyone can observe, that doesn't necessarily mean that lawyers can automatically treat video conferencing as identical to open court. Remember, in the courtroom, the judge can observe everything happening and everyone present. In a virtual hearing, however, the judge can only observe what is on the screen. Anything outside the frame is invisible to the judge. As a matter of professionalism and even ethics, the way we might think of a lawyer allowing another person to be present in the video conference but invisible to the judge is an act that could lack candor. If the lawyer or the lawyer's client has someone else present for the hearing but the judge doesn't know it, this could be, at worst, seen as a kind of misrepresentation to the court. That is, it is probably best for the lawyer to inform the court of the person's presence so that the judge can know of everyone who is present. Even knowingly allowing others to be within earshot might be problematic. Although a lawyer cannot guarantee that a person won't overhear the court proceeding, it might be incumbent on the lawyer to act reasonably to limit the potential for others to overhear. As we've said, a judge in a physical courtroom can monitor who is in the room and hearing the proceeding. Sometimes it may be vital for the judge or the other parties to know who can overhear the proceedings. The disclosure of sensitive information, the sequestration of witnesses, media limitations, and other considerations might make it particularly important for a judge to be able to carefully regulate courtroom access. A desire to act with integrity should motivate a lawyer to reveal the identity of those who can see or overhear the proceedings, or take reasonable steps to ensure that others cannot, particularly when they have no reason to be present. In addition, lawyers must be mindful that not all proceedings are open to the public. A deposition, for example, while considered to be before the tribunal, isn't open to the public. The Florida Bar has even advised lawyers taking depositions remotely to admit only participants entitled to be present. And of course, lawyers must keep the information related to the representation confidential for the benefit of their clients. Court proceedings may not implicate the full range of protections that a lawyer might afford for attorney-client privileged communications, but for ethical purposes, disclosing client information is permitted only in limited circumstances, including when that disclosure is appropriate in carrying out the representation. So making disclosures in open court that advance a client's case would be an ethical reason to disclose client information. However, allowing others to sit in unannounced or overhear remote court proceedings without the judge's knowledge is not necessarily acceptable from a client confidentiality perspective. All of this means that lawyers must find private and secure spaces to conduct video conference court hearings.
Hey guys.
Hi.
Hey, you're Bonnie, right?
I am.
Hey, let me ask you a question. Do you use video conferencing for work?
Sure, of course.
All right, so let me ask you a follow-up question. What do you think judges dislike the most when someone's video conferencing?
Well, I've never appeared before a judge on Zoom, so I'm not sure that I know.
How about take your best guess?
If I had to guess, I'd say it's probably the same things that make me go crazy on Zoom. So too much background noise, people forgetting to mute, pets running in and out of screen. No, I would say judges probably don't like people who show up too casually dressed.
Bonnie got a lot of correct answers here. Judges have lots of concerns about the way lawyers appear before them on the screen. Professional dress. Judges complain that lawyers do not dress appropriately for court when they appear by video conference. Here's a good rule of thumb. If you wouldn't wear it in the courtroom, don't wear it in the virtual courtroom. Advise your clients if they appear with you to dress appropriately for the forum. As officers of the court, lawyers should uphold the court's integrity and reputation for professionalism, and professional dress communicates that. But there is also self-interest here as well. By dressing professionally, a lawyer communicates respect for the judge, and that helps the lawyer create a positive impression. Background noise. Judges point out that background noise is a problem, and the source can often be pets, household members, or other shared office or home noises. When working from home, choosing a room with a door you can close is a good idea. A trip to the office may be a good idea if home is too busy to ensure a quiet environment. At the very least, mute your microphone whenever you are not talking. That will help diminish background noise. Interruptions. Interruptions are a problem for judges when conducting effective court proceedings. With remote hearings, the chance of these interruptions occurring increases. These interruptions range from someone else entering the space to technological interruption like a ringing phone. A distracting sight for a judge in a video conference is to watch a lawyer's eyes veer from the screen to land on something else or someone else not involved in the proceeding. All participants may wonder, what is going on? Who's in the room? Should they be there? A good practice is to put a Do Not Disturb sign on the door and do the same thing with electronics. Turn on Do Not Disturb on your phone. Close your emails and chats to ensure they don't beep or ding during the hearing. Judges want an interruption-free proceeding. What's Chris got for Bonnie now?
All right, Bonnie, let me ask you a follow-up question. Do you think on video conferencing that body language, nonverbal communication is more important or less important?
Definitely less important.
Why do you think that?
Well, the screen is pretty small, so you're not really seeing much of them anyway. They're not moving a lot. If you think about newscasters like the Anderson Cooper types, they're sort of emotionless, don't have a lot of things going on, they're kind of stoic, so nobody really seems to have a negative impression of them. So I definitely say less important.
Bonnie is definitely more wrong than right. Although participants in a video conference are physically distanced, they still read each other's nonverbal cues, facial expressions, and gestures while interacting. As Bonnie points out, that screen is often small, and if there are many people on a video conference in gallery view, it might be even harder to see and interpret the facial expressions and gestures of others on the video conference. Yet nonverbals are important for communicating our message, whether in person or on screen. Verbal communication sends only a small part of our message. Our body language and facial expressions are significant in sending signals about our meaning and intention. In fact, a significant part of our emotional messaging is sent through our nonverbal communication. We send messages about our interest in others, honesty, and comfort through our eye contact. Our gestures emphasize our verbal communication, can conflict with those messages, and send messages about our emotional state. Head nodding and leaning in can convey our attention and interest. Our facial expressions communicate our emotions. When we are in person, the space we maintain between ourselves and others sends a message, as does our decision to touch others, through a handshake or a pat on the back, for example. If you're still not convinced how much we communicate through nonverbal messages, consider how difficult it is sometimes to understand a person's intention in a text-only message like email. Because our nonverbal messages are important, and because communicating those messages on screen is more challenging, attention to one's body language is more important for on-screen communication rather than less. What are some of the things that you can do to improve your on-screen communication? Maintain good eye contact. This isn't easy because, like those newscasters, lawyers are talking to a camera rather than a person. Thus, we need to think of eye contact differently for on-screen communication. That is, we need to think of creating the perception of maintaining eye contact rather than actually maintaining it. One way to handle this is to get your screen at eye level. If you have an adjustable second screen, put your screen on level with the video camera as best you can, so that at the very least, when you are looking at participants on screen, you're also looking in the same direction as the camera. While listening to others, you don't need to stare into the camera. Instead, watch other participants' facial expressions and body language. The placement of the camera in the same vicinity as the screen helps maintain the feeling of eye contact while you're observing others. But when you're talking, do your best to simulate maintaining eye contact with participants by looking at the camera when you speak. Remember, at least in Western cultures, many people judge speakers' credibility by their eye contact. Frame yourself to capture gestures. Position your camera at eye level to maintain good posture. Frame the camera to capture not just your head, but at least some of your body. And capture your hand gestures. Think of those newscasters and how we can see some of their bodies when they're talking. If you allow other on-screen participants to see more of your body, you can convey messages with gestures and improve your chances of others interpreting your messages as intended. Emphasize nonverbals that show you are actively listening. Much of the time you are on screen in a court proceeding, you will be muted, so giving verbal feedback to participants while they are speaking is challenging. Think about the ways you can convey that you are listening attentively to others through your body language. Remember that the courtroom is formal. You will want to be subtle and measured in your active listening cues. A head nod is a good choice for active listening, depending on the context. Imagine a judge describing the limits on discovery at a pretrial conference. While listening, you can nod intermittently to show that you understand what the judge is saying. This will send a message to the judge that even though you are physically distanced, you are present with the judge and engaged in the conference. Be extra mindful of facial expressions. Unlike in face-to-face courtroom interaction, participants are likely looking at you often. Think about it. In a courtroom, you might focus on the judge and then turn to look at opposing counsel when he speaks. You might then look at the witness when she answers a question. After that, you might look at the clerk when you offer an exhibit. You're not looking at everyone all at once. In video conferencing, however, everyone is looking in the same direction at that gallery of people on the screen virtually all of the time. We are more or less looking at everyone all at once. This increases the amount of time others are seeing you. While we may not like it, we are more intently surveilled by others in a video conferencing setting. Facial expressions send a lot of information about our cognitive and emotional states. Our faces express joy, sadness, confusion, disgust, skepticism, anger, and more, and we tend to take facial expressions seriously. Thus, when on screen, be extra aware of your facial expressions. Think about using your facial expressions to help convey the message you want. If you want participants to know that you're confused, furrow your brow. If you want to convey warmth and openness, smile. If you want to express disapproval, a stern look. If you don't want to give up your cards, keep a neutral expression. In other words, in an online setting, pay attention to aligning your facial expressions with your intent. I think we'll leave our conference goers alone for now. They were a big help in thinking through this new world of court video conferencing. And as you head out, remember our 2 big takeaways. First, if you practice in the civil courts in Florida, new rules make appearing before the courts by video conferencing more likely than ever. And second, when you sit down in front of that camera for a court proceeding, remember that virtual courtrooms are courtrooms, and you want to be effective, ethical, and professional. See you next time.